Hi, I'm John Counsell. I'm a senior reporter with Texas Lawyer newspaper, and welcome to the March 2nd, 2009 edition of Reversed and Remanded. My guest today is Robert Udashen. Robert is a partner in the Dallas office of Sorrells, Udashen, and Anton, where there's two Udashens, you and your brother. And he's a criminal defense lawyer, and a really good one. So I'm going to have him talk about the big story in our paper this week, and that is the guilty plea of U.S. District Judge Sam Kent. He pled guilty to obstruction of justice, and you know, as a judge told him, we're not referring you to as Judge Kent anymore. We're referring to you as Mr. Kent. So, Robert, the way I understand it, pleading to obstruction of justice, that's a charge that I think carries a maximum of 20 years in prison. The plea agreement, I believe, the government has agreed to only ask for a maximum of 3 years. And he has a sentencing date, I believe, in May. So if you're his criminal defense lawyer, what are you going to advise him to do between now and then? What are you planning on for the sentencing hearing?
Well, what's going to happen at this point is a pre-sentence report is going to be prepared on Judge Kent by the probation department in the Southern District of Texas, and it's real important to both work with the probation department and get together information that might mitigate any sentence. So you want to get a psychological evaluation done if it hadn't been done, and present information about that to the sentencing judge that might help explain why Judge Kent did what he did. You want to present character letters to the sentencing judge to tell the judge about Judge Kent's good character. Can we expect during his sentencing hearing that we'll have a parade of witnesses coming to explain his years on the bench and what type of judge he was? I mean, do you think we'll see that? Well, it's possible you see that, although I know they brought in a judge from Florida to handle the case. And I don't know what that judge's practices are. I mean, every federal judge has different ideas on how many witnesses to allow in person at a sentencing hearing, and a lot of federal judges put limits on the number of witnesses you can call. And so a lot of this will be done in writing. I mean, you'll have written letters from character witnesses, you'll have a written psychological report if they choose to do that. And now Judge Kent would have an opportunity to speak in person at the sentencing hearing if he wanted to do that, and his lawyer, Dick DeGuerin, of course, would be able to speak at the sentencing hearing. Okay, so from what you know about his plea agreement, what are the chances you think that he's actually going to see the inside of a prison? Yeah, that's a really tough question. I think the judge from Florida is in a difficult position, because you don't want to treat Judge Kent differently or more leniently just because he was a federal judge. Because I think you're really subject to criticism for that. So I would expect that the judge will try to do what he would do if with any other person who might be charged with these types of offenses. Now, let's say he does get a prison sentence. Where do you send a federal judge that sent thousands of people to the place he may be going? And that's one of the things that complicates matters, and I do think, and this is where a sentencing judge may be torn in thinking that you have to treat him more leniently because he might be in danger going to some federal prison where he has sentenced people for drug offenses and serious crimes. Typically, a federal judge can't control where the person goes. I mean, so you sentence. Judge Kent, if he's sentenced to prison, would be sentenced to the custody of the Bureau of Prisons. The sentencing judge can make a recommendation on where he should be placed, but ultimately it's up to the Bureau of Prisons to decide where to put him and how to protect him from anyone he may have sentenced who may have some grudge against him. And they do have procedures for that, because police officers sometimes go to prison, public officials sometimes go to prison, and they've got to deal with that. No, that's true, and so the Bureau of Prisons is used to doing that, and so I'm sure they could provide protection for him should he be sentenced to prison. Okay. Second issue is there's talk of a eyewitness bill being filed, and what witness identification bill, which would change the procedure that police use when they put a lineup in front of a crime victim. And as you know, Robert, this has become a big issue in DMA exoneration cases here in Texas, because it seems like every time we see one of these, more often than not, there's a faulty witness ID.
I think the proposal is what requires, or at least strongly encourages, a blind witness where the police officer is unaware of who the suspect is when he's presenting the photos to the victim. Is that a start, Robert, or is that something that you think is going to pass?
Well, it is definitely a start. Whether it'll pass or not, I don't know. I think a lot of police departments, people in the law enforcement community will be opposed to having that bill on the books because they don't want to be mandated on how to carry out their investigations. Now, on the other hand, the DNA exonerations in Dallas, particularly, and my firm's been involved in almost every one of those,
right,
really shows that there is a problem with eyewitness identification, and that's consistent with all the research that would indicate that doing blind photo lineups where the officer showing the lineup doesn't know who the suspect is a better way of doing things, because even a well-intentioned officer can unintentionally signal the witness who to pick.
Right, and I guess you don't want to put a way for a law enforcement agency, one that's well-meaning and is trying to do their best job, a way to trip up. I mean, you don't want to lose a good witness identification because a specific procedure wasn't followed. I know, I understand there's a fairness issue here, but then again, there's protection of society question as well.
No, and that's what makes it hard, because from law enforcement's point of view, the more you specify the procedures they have to follow, the greater the risk is that someone will make a mistake, and a case will get thrown out that may be a perfectly good case.
Yeah.
Part of the problem that I see with eyewitness identification over the years is that there are procedures in place that the Supreme Court has mandated that require identification procedures to comply with due process.
Right.
And a lot of trial judges over the years have been reluctant to suppress faulty identification procedures and thinking that the jury can sort that out.
Right.
And I hope that the DNA exonerations might encourage trial judges to look more closely at what's gone on in eyewitness identification and just follow the law that's been mandated by the Supreme Court for years.
Yeah. All right, now it's time to put Robert in what I like to call the witness stand. I'm going to ask him some crazy questions and see what he has to say. All right, first question, Robert. Have you ever had a client say to you, "Look, Robert, I am so guilty. Can we just get this over with real quick?"
Yeah, well, I have had a client say that to me before. Yeah, although I like to tell people, I normally just represent innocent people.
Yes.
And so I usually, in my firm, what I do with people that say that is tell them, Bruce Anton's your man. Okay.
All right, Robert, what's your personal record of number of objections made during a single trial?
Boy, I've practiced for 31 years. I don't know that I've ever gone back and added things up. I will have to say that on occasion when I read records for my trials, I thought I really didn't make many objections, and sometimes there's objections all through it. So I, off the top of my head, I've probably seen cases where I may have made 100 objections during the course of a trial, but for a long trial, that's not too bad.
You got to have a personal best if you're going to beat it, Robert. All right. Okay, final question. After you defended an admitted axe murderer and got a not guilty verdict, is it all downhill from there?
It is downhill from there, and that was tough because that case was. I was a 3-year lawyer at the time I did that case, and then
just a little background. Rob, this actually happened. Robert defended in 1980. A woman accused of an axe murder, and at the last minute, you had a trial strategy change, and bang, won.
Yeah, well, and people find this hard to believe that are familiar with the case, but that was a self-defense case.
Yes.
And I did win, but it sets the bar really high as a young lawyer, because then everyone coming in, particularly shortly after that trial, thought, well, if you can get this lady off who whacked another lady 41 times with an axe, why can't you get me off?
You're a victim of your own success, Robert.
Exactly.
Robert, thanks for coming by.
Thank you, John.
All right. Bye-bye.
Bye.